Hi, this is John Veely, CEO of Online Visas, and today is Friday. Woohoo! So we are showing you this episode or hosting this episode of how to practice law in a Hawaiian shirt. Today, I'm going to talk about immigration. I'm an immigration attorney, so that's appropriate, I believe. And I really want to go over 8 things to do with the Trump immigration ban. What might happen next? What might happen next? 8 things that following the Trump immigration ban on what, just different items that we can discuss. So one of the things that the administration noticed is the possible loophole that people could enter the United States on a B1, B2 visitor visa and then change their status, and they would not be barred from the United States. So there is discussion that they may have a fix to the B1, B2 visitor visa loophole sometime in mid-July. So boo to that. As if it wasn't bad enough, they want to make it a little bit rougher because they didn't think of something. So was thinking about that. Now, the Trump administration has changed one thing early on, and that had to do with intent. So when you enter on a B1, B2 visa, even if you don't say it, you are stating that you intend to leave at the end of, that's typically 6 months or 180 days. So it used to be that you could change your intent after 60 days. The Trump administration has changed that to 90 days or 3 months. And that is really coincides probably with the ESTA visa waiver that's at 90 days. So if people came in and they decided to maybe get married or something like that, they'd have to wait 90 days to do that. So they may already have figured out how to mess with anybody anyway. So if they came in on a visitor visa, wanted to change to an H-1B, H-2B, J, or L, they would have to wait 90 days anyway, but we'll see what happens. And we'll see if they may, there's been some discussion out there that we've heard about, and it may not be as bad as they thought, but we'll see. Number 2, they're looking at, further issues with the EB2 and EB3. That's the Perm Green Card. So let's see what that will be like. There's also some points on that they may be looking at how to redo the H-1B lottery and how it's administered. The INA, or the Immigration Naturalization Act, is pretty clear on that. But this administration hasn't always been felt tethered to these regulatory laws, and they may just do what they want to do, which we'll get down to lawsuits also later. So the next thing, though, is really so regulatory changes that have been called for in that might really be around wages. So we've heard a couple of different things: minimum wages. The thing we've heard lately is level 4 wages. So what I mean by level 4 is Department of Labor in their labor condition application, or LCA, when someone puts in an H-1B visa, has thresholds of levels. Level 1s are entry-level jobs. Level 3s are managerial level jobs. Level 4 is the highest level job there is. So mandating that's a minimum. That's one thing. Another thing that they might do, which is really interesting, is come up with instead of indicating that the wage is tied to a county or state, we often go to the FLC data center and look at that. And if you do H-1Bs, you know what I'm talking about. Or you can go to the National Prevailing Wage Center to get that. They have not mandated that H-1Bs go to the National Prevailing Wage Center like the EB2 and EB3 green cards. So you can go to the FLC data center and pull that down. But you're looking at how much does a job pay in places like Cleveland County, Oklahoma, as opposed to Manhattan, New York, or San Francisco, California, right? So if they come up with a across the board salary, that's really going to hurt the lower population areas. And interestingly, the Trump supporters are really in those areas, whereas the people that are kind of against him are in the big urban centers. But they would see the benefit, and the Trump supporters would not see the benefit of that if those are companies that want to file for green card, or I'm sorry, H-1Bs. So that'll be interesting to see what they come up with on that. Stay tuned for that. If you're watching this on YouTube, please subscribe and turn on your notifications. We'll keep you in the loop on this thing, and leave comments, and we'll get back to you. But this is sort of stuff that will be coming soon. We'll keep you up to speed on. The next thing is filing suit on this. Is this violation worthy of a lawsuit against the president of the United States, or which would pretty much be it. So there's a concept called ex parte Young that allows you to sue a a United States federal government official if that official acts outside the scope of their authority. So we've seen some lawsuits. The IT Serve Alliance lawsuit, for example, was against Francis Cisna because he was sitting in the position of at the Secretary of Homeland Security. Okay, so this was an executive order. So this would be a lawsuit against President Trump in his official capacity if he went beyond his official capacity, which is 212F of the INA, or Immigration Naturalization Act. Now, that INA gives him pretty broad discretion, but is it enough to go into non-immigrant visas? And is it enough to say it was the COVID-19 deal? Or is it too broad because he's attacking an entire visa instead of just people who have maybe tested positive for COVID-19? Right. So these are things that are out there. So will there be a lawsuit? Who will bring it? And what's that going to be like? Because if there is a lawsuit and they find that there was an emergency scenario, which is likely in this scenario, you'd get a restraining order, a temporary restraining order maybe, that to enjoin or an injunction the president from applying all or part of this proclamation. You might be able to hold that off. Now, he could appeal that from the federal district court to the courts of appeals. And it would be interesting where you brought the case. D.C. is a likely place. They're very good at understanding the technical ways of dealing with administrative law, and that's what this is. This would be an administrative law lawsuit. Now, it says suing Donald Trump. It's suing the White House or the president in the presidential capacity, and really over the kind of boring machinations of a regulation, right? So these things happen every day against all the agencies, FCC, SEC, all the different three initial agencies out there have lawsuits at them all the time on how regulations to be applied. So this isn't sexy really, but it'll be interesting, because really how impactful this proclamation has been on so many companies being able to hire who they need. So that'll be interesting. The next thing is something that I find very, very fascinating as a lawyer. And if you want help on this, please go to onlinevisas.com and schedule a strategy session with us. But it's going to be waivers for each of those instances of the H-1B or L-1 or H-2B. And there's a couple of different categories that do not apply. There's the food service industry. How far does that apply? Does it apply to people stocking, under the H-1B, they're stocking, the shelves at grocery stores? Are they working in restaurants? Are they cooks? Are they things like that? Are they managers in restaurants under the H-1B? Are they working for companies? At what extent do you have to be in the food service industry to do it? There's the national waiver. There is whether or not you are a nurse or a doctor dealing with COVID in hospitals. How broad is that? See, I love this as a lawyer because you can get creative. And what it means is that you do the H-1B anyway, and then you get your approval, and then you set it up for your consulate, and then you create these arguments to win the waivers. And you got to do it at the Secretary of State level. So we're really interested in working with you if you want to talk about that. So check us out on that. Another thing that's been trending across the social media sphere, the blogosphere, the Facebookers, Twitters, is S-386. That was a bill that had some traction back in December about removing the priority dates for Indians, who are very, very long on those. But with removing the priority dates for Indians and putting it across the board, it means everybody slows up a little bit. And that could be a big deal. And there's, as they say, kind of a price you pay for that. There's Grassley and Durbin, different sides of the aisle that would have pushback on that. It'd be interesting. So we'll see what's happening on that bill. I haven't seen a lot of it lately, but that's one thing that we've seen coming out there. And then is the funding for DHS and the furloughs. They need $1.2 billion to make up for all the lost revenue by less people filing cases because of these administrative scenarios and just a chilling of the economy. And if they don't get it, they may lay off, tens of thousands of employees. I don't know if it's a third or 2/3 of their adjudicators. And I don't know how they're going to do that, but that might be the nail in the coffin that really hurts a lot of these cases. Now, we don't know if that'll happen. Congress can still allocate some money for it, but we'll see how interested they are in this. Immigration's is a political football, and we'll see what they do. There's a lot of need for people to still come in. We got to get the economy, keep it rolling right now. And that's one of the reasons too. Rebuilding the economy is one of the H-1B waiver processes, and that's a fun one to think about. So anyway, those are my 8 things to talk about practicing law in a Hawaiian shirt. Hope you learned a little bit more of how you do it, and have a wonderful 4th of July weekend. Stay safe, wear your mask, and we'll see you next week. This is John Veely, CEO of Online Visas, and we deliver dreams.